Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look at another extremely significant case decided by the High Court of Australia. The case is Victoria and the Commonwealth from 1971, also known as the Payroll Tax Case. Can the Commonwealth use its taxation powers under Section 51(2) of the Australian Constitution to impose a tax on wages of state's civil servants? If you are subscribed to our channel, you're probably trying to remember the videos that we recorded about the engineers case, about the Melbourne Corporation doctrine, and another case called Cigamatic. If you haven't heard about any of these cases, then you should first subscribe to our channel and then go and watch the videos that are appearing on the playlist that is linked here in your screen, because there I talk about a bunch of constitutional cases decided by the High Court of Australia. We come to this case knowing of another case decided in 1920 called the engineers case. In that case, the High Court decided to adopt a literal approach to interpreting the Australian Constitution, and that led to an expansion of the powers of the Commonwealth. This was later on tempered by the Melbourne Corporation doctrine. However, even still, as we saw in the Cigamatic case, the Commonwealth still has predominant powers over the states. So since the engineers case, the balance has been tilting towards giving more powers to the Commonwealth. And here we are in 1971 trying to see if the Commonwealth taxation powers could be used to interfere with states' businesses. So, without further ado, let's go to the facts of the case. The Payroll Tax Act of 1941 imposed a payroll tax on an employer, but the term employer in that act also included the commonwealthing right of the state, and not only private employers. And the tax would be levied according to the wages that were paid by the employer. The state of Victoria, as an employer, paid wages to public servants in the hardcore departments of that state, like the Premier, the Crown Law, Victoria Police, etc. So Victoria sought the High Court, affirming that the Commonwealth could not levy the wages of public servants to tax states. And because of that, Victoria wasn't required to pay the payroll tax. So, the question before the High Court was, could the Commonwealth use its taxation powers under Section 51(2) of the Australian Constitution to tax the wages of public servants even though they were exercising the primary governmental functions of the state of Victoria? Do you see the problem? Even though you may be thinking, yeah, I see the problem because of the Melbourne Corporation doctrine, the High Court just answered yes, unanimously. It is possible for the Commonwealth to tax the state of Victoria. Just like it happened in the engineers case with the arbitration powers of the Commonwealth, so it happened here with the taxation power. The same literal approach that was used in the engineers case to interpret the Australian Constitution was also used here to interpret the extent of the taxation powers of the Commonwealth. But this decision also recognized the existence of the federal scheme. It still considered the structure and the purpose of the Constitution. And the court even said that the Commonwealth powers should be read according to these aspects, just like the Melbourne Corporation doctrine. How did they do this? How did they decide to interpret the Constitution literally and therefore give more powers, or at least expand the scope of the powers of the Commonwealth, and still maintain a federal balance? The court reasoning referred to two things. One, that there are no express limits in Section 51(2) that could prevent the Commonwealth from taxing the states. And two, that although the Commonwealth could not tax the states as to prevent them from functioning as states, like the Melbourne Corporation doctrine taught us, this was not the case here. So let's take a look at some of the opinions of the justices in this case. Justice Menzies recognized that Australia is a federation, and therefore this brings some implications on how Commonwealth can exercise its lawmaking powers. So these Commonwealth legislative powers, when it comes to the states, they are limited. However, he said that there was no issue with the payroll tax in this particular situation. The tax did not prevent Victoria from functioning as a state. Following the same thread as Justice Menzies, Justice Walsh said, "Clearly the laws here challenged do not prevent the states from performing their functions, and in my opinion, they do not in any relevant sense impede them in doing so. There is not, in my opinion, any ground upon which it could be asserted that the challenged laws, insofar as they bind the states, bring about any such destruction or curtailment of the right of the states to continue in existence or to exercise their functions." Justice Gibbs reminded his peers that the tax has now been imposed upon and paid by the states for nearly 30 years, and it has not been shown to have prevented the states from discharging their functions or to have impeded them in so doing. So, in conclusion, I'll use the words of Chief Justice Barwick to summarize this decision. He said, "The Commonwealth Parliament, in exercising its legislative power as to any of the enumerated topics, is able by its law to bind the crowning right of a state, except in relation to those topics which contain an express exception or limitation in that respect." As the High Court acknowledged, a tax law could still discriminate against a state or prevent it from functioning as a state, and that would infringe the Melbourne Corporation doctrine. But that was not the case here with the payroll tax. All in all, the High Court here integrated the literal interpretation of the Australian Constitution conceived in the engineer's case with the limitations, at least the literal limitations, that the Melbourne Corporation doctrine imposes on the Commonwealth power to enact laws that will affect the states. In the end, the state of Victoria had to pay the payroll tax to the Commonwealth. I hope you liked this video. If you did, don't forget to leave a like. And also, before you go, join our Aussie Law community by clicking the subscribe button and enabling the notifications. I hope to see you soon. Until then, ciao.